All right, joining us via Zoom to help us make sense of these issues is lawyer and advocate for good governance, justice and equity, Liberus Oshoma. Liberus, good morning. Thank you for joining us at TVC Breakfast.
Yeah, good morning.
Now, the Supreme Court had made a pronouncement that these payments were unconstitutional, yet we still see the Attorney General of the Federation and some consultants making a case for these monies. Help us make sense of this.
Yeah, thank you. But first and foremost, before I go into that, I would say that if you observe recently, in every allegation of sleaze or compromise against any agency of government where governors are involved, Governor Yari's name is mentioned as Chairman Governors Forum. So there's need for detailed and further investigation on the activities of the Governors Forum in the era of Governor Yari. That's on one side. And on the Paris Club reform, there's been controversy, there's been back and forth, there's been news here and there. The issue is, in one breath, the parties agreed that there is a matter before the Federal High Court, which is on appeal presently at the Court of Appeal. And then there's allegation also, the Attorney General had insisted that there's a Supreme Court judgment. Ned Nwoko had debunked that allegation that there is no Supreme Court judgment, and that if there is any Supreme Court judgment, he's ready to forgo his money. None of us had seen that Supreme Court judgment. I haven't seen it. And in that vein also, I also do not think that it is the duty of the Attorney General of the Federation, even though, according to the Attorney General of the Federation, the federal government guaranteed that payment and the state governor signed an indemnity letter or form for the federal government. Being a matter before the court, I do not think that it is the duty of the Attorney General to begin to implement a court decision. That's a court decision when the matter is on appeal, especially given the fact that the Attorney General is not a part in the matter. He just said that the consultant wrote a letter to him and wrote a letter to Mr. President, and Mr. President sought for his legal opinion on the matter. And to that extent, he went ahead to instruct that payment be made, despite the fact that the matter is currently pending in court. I also like the fact that Mr. President had instructed subsequently, after initially ordering payment, subsequently on the advice of the Federal Executive Council, instructed the Minister of the Finance to halt payment, because first and foremost, it is also not at this time not at this time in the day where we are grappling for foreign earnings, that the federal government will be paying $418 million, especially also given the fact that there are controversies surrounding all of the allegations. And then lastly, I would say, if you remember, sometimes last year, I did accuse the Abia State government of deductions and percentage made on this same Paris Club reform. Because if you remember, after the reform had been made, the governors forum, headed by Yari, then also created a subhead and a contractor deduction from source the moment the payments were made. And then some state government also appointed consultants to help recover money that have been recovered. So there were a lot of subheads and then sleaze surrounding that reform. Ned Nwoko had also said that EFCC, the matter is too technical for EFCC to handle. I do not think so. I also do not think that it is too technical for EFCC to handle. If the accusations of underhandling, especially given the fact that he had accused Yari also of collecting $100 million for and on behalf of other governors for the prosecution of an election. Is that not a criminal allegation that will warrant our security agencies and our financial crime experts to investigate? I think that should be. So I quite appreciate the concerns of all parties, but I think the sensitivity of the matter would ensure that this matter is handled with caution and allowed, and since parties have submitted the matter before jurisdiction of the court, allow the court to, exhaust, its powers in arbitrating or litigating over the matter.
But it seems from what is happening that both sides seem to be afraid of the courts? Because if this matter is still at the courts, why are we having this conversation and accusations?
That's the issue with Nigeria. You'll find out that we submit a matter to the jurisdiction of the court. Also, because there are windmill of justice here grind slowly. We say windmill of justice grind slowly but surely. But we also forget that justice delayed is justice denied. So you have some persons who claim to have worked, and like we say, a laborer is entitled to his wages. And payments were made in some trenches, and subsequently payments were stopped. And all these parties went to court. I know of individuals also who also had taken states to court, as regard the same reforms. So because there are delays, I think the parties now decided to use other means. But in using other means, since you have submitted to the jurisdiction of the court, other means should not be calling on Mr. President to override the court. Other means should be an alternative way of resolving the dispute, whereby both parties sit down and reconcile figures. The idea of now writing to Mr. President to come to their aid when a matter is in court. I also think that the Attorney General, that's why I think the accusation from the Governors Forum against the Attorney General that is self-serving, for me, I also want to agree with them that a matter that is in court, even if your legal opinion is sought on the matter, all you request for is to ask for a judgment that had been delivered, and then the processes filed in the current one that is in court, and not to now hastily give a judgment or in a matter that is in court, saying that government has, since there was an indemnity fund, bond signed by the governors to the federal government, since the governors had guaranteed payment, and the federal government had guaranteed payment, an indemnity fund was signed against that guarantee, then the federal government should release the funds. What you're trying to do is to foist a fait accompli on the court in the event that the court determines the matter one way or the other. I think the opinion and advice should have been to Mr. President that since the matter is in court, which has always been, the opinion of federal government in matters they don't want to get involved in. They tell you the matter is in court. Look at Nnamdi Kanu's case, for example. Even when the Ohanaeze Ndigbo and Igbo elders went to appeal to the government to find a political solution to such matters, the president said, well, the matter is already in court. He didn't even seek the opinion of the Attorney General. But in this case, the matter is in court, judgment had been delivered in some cases, and everybody's aware that there's an appeal on that judgment. The governors are crying foul. The consultants are also crying foul. Now they've submitted their claim to the jurisdiction of the court. So there is no need even seeking, let's assume that the president is not even aware that the matter is in court. The moment the Attorney General became aware of that fact, the best thing to do would have been, well, guys, you have submitted to the jurisdiction of the court. And the best we can do is to ask the court to hasten decision and not to now begin to give a judgment or enforce an order that was not made by the court.
Liboros, it's significant that this matter is coming to a national reckoning. What baffles me is the paradox of the situation, that the person who is owed is supposed to be the one going to court. But the thing is upside down, that the person who actually paid, went into the case, who is supposed to be the
arbiter,
the debtor or arbiter, is the one going to court on behalf of those who are aggrieved.
You see, that's the absurdity of the Nigerian situation. If you listen to Ned Nwoko, he talked about only his claim and said, I also think that press interview was not in good faith, even though there were some revelations made. Because if you, there are allegations that deductions were about $418 million, and you know that there are other consultants. And if you believe that as a lead consultant, you're working in tandem with other consultants, the best thing to have done in that circumstance would be to collate all of the claims of other consultants, but to come out and singularly speak about yours and made it look as if that is all there is, that what is owed is 68 million, and you do not know where the figures the governors are banding came from. Only for the governor to respond and break down all the claims as it is. You know, you put a hole in that claim. And then secondly, you have submitted a matter like I did acknowledge. You submitted a matter before the jurisdiction of the court. Why now write a letter to Mr. President for his intervention? I think the best thing would have been you withdraw the matter before the court, and then you now begin to seek for alternative way of resolving it. Also, the people, it is for me, I'm still grappling to understand the rationale behind, you know, the interest of the Attorney General in the hasty payment of the sum owed, alleged sum owed, while you are aware that the matter is in court. And then, like you also observed, the people that are being owed are not the one that have approached the court. They should have been the one to approach the court to say, these are our claims. And there is a valid agreement entered into by parties, and you join the federal government that guaranteed the payment, join the state governors that are owing the money. But in this case, that is not the issue here. There are claims that there's a Supreme Court judgment nobody has seen, that there is an order of mandamus. The Attorney General is also claiming that there is an order of mandamus against the federal government, directing the federal government to pay the money. Why there is also the allegations from the governor that there is a Supreme Court judgment. And also, parties are aware that there is a current judgment, there is a current matter pending at the Court of Appeal. All of this, they are conflicting orders. I also have expected that the Attorney General ought to have studied all of the orders, including, like I said earlier, including the pending matter. And then before you now take a decision, and not select the judgment to obey, and then, you know, decide not to obey the order.
All right. Mr. Sharma, let me ask you perhaps two questions in one. Do we seriously need consultants to carry out this kind of transactions, or to mediate for this kind of transaction? Do we really need them? Are they very essential? And then two, we find ourselves in a JAPA area where people want to leave the country, but we're in a global era. How damaging is this kind of story or reports for the country as a nation?
Yeah, first and foremost, it depends on the job of the consultant. If the state government are not even aware that the deductions were made from their funds, and that the consultants were the ones that revealed those deductions, then the state will need consultants to sit down, financial consultant or financial analyst, to sit down with them and look at all of the illegal deductions. So just like you employing a financial analyst to look at your bank statement and point out, because on the face value, you will not understand the excess charges or illegal charges by the banks. But when a financial consultant who is trained in the act of looking at the fine lines, look through those documents, he'll be able to point out excess charges. That was what happened in the case of Guaranty Trust Bank and Innocent Motors. They employed a financial consultant to look at both books. So in that regard, if that's the case, then certainly you need a financial consultant. But if the case were that, illegal deductions had been identified by the Paris Club and the London Club, and then they decided to make refund, then in that circumstances, you don't need a financial consultant. You have commissioners, who are also, knowledgeable in this field. You have attorney generals who also will sit down and draw up an agreement with the banks making the refund. And so in those cases, you don't need a refund. But typical of Nigeria, whether you need consultants or you don't need consultants, we employ consultants to do everything. And that's why there is allegation against the former chairman of the Governors Forum, Aziz Yari, that even after the refund had been made, the Governors Forum appointed a consultant for and on behalf of the Governors Forum because they needed also to make deduction. In some states, even after refund had been identified, those state governments still appointed consultants. The case of Abia, for example, there were 2 consultants appointed, one claiming a percentage of 30%, another one claiming a percentage of 15%. So for the refund, if you take out 45%, what is left for the state, the poor state that is grappling for funds? And like you also identified, in this era of global financial crisis, and Nigeria's case is peculiar, one would have expected that the federal government, the state government, and the the consultants sit down like the federal government had done now, setting up a committee headed by senior advocates. I also think the Minister for Finance and the Minister for Budget and Planning and experts in financial figures should also be part of that meeting. It's not just to look at the agreement, but also to look at what was recovered and how percentage ought to be paid. Now, even your dollar that you have in your account, that you have deposited in your account, to withdraw it is a problem in Nigeria. And then government, if the Attorney General of the Federation is so much in a hurry, is in haste to dole out $418 million to some consultant, despite the fact that the matter is in court. For me, it's shameful.
From your point of view, Liberus, what do you think might be the Attorney General's interest in this matter?
Just like the Attorney General attempting to execute a court judgment in Lagos, despite not understanding the intricacies of the matter, I think our Attorney General, a lot of people had called for the NBA, had made calls to the NBA to sanction the Attorney General. I think this is more of a personal interest than the interest of the federal government. Because if you say that there is an order of mandamus, directing the federal government to make deductions and pay to these agents, and the governors are also laying a counterclaim saying that, no, there is such order has been appealed against, and there is another pending appeal. I think, and as an Attorney General, who is the chief law officer of the state, and also doubles as the legal advisor to the government, as an arbiter, what you should do is to look at the cases of both parties. If possible, call both parties to a round table to sit down and look at how the matters can be resolved amicably. Also, putting national interests at heart at this critical stage that we are in, considering the financial crisis we are in also. But to hastily make that judgment, the only deduction I can deductions I can draw from that, inference is the fact that the Attorney General, has personal interest in the matter. And we all know also consultancy. I'm not saying that it's probably been promised some consultancy, but if you make this happen, we know the way Nigerian businesses are run. If you make this happen, you have a certain percentage. So all of this will fan, personal interest to ensure that you use your power, for personal interest. It's against national interest.
All right, Liberals, we need to quickly go on a commercial break. When we return, we'll continue the conversation with you. Stay with us. Thank you for staying with us. Before we went on the break, we were looking at the controversies surrounding the Paris Club refund, the allegations, counter-allegations between the Governors Forum, the consultant, and also talking about the interest of the Attorney General of the Federation. And we have been speaking with lawyer and advocate for good governance, justice and equity, Liberus Oshoma. Liberus, are you still there?
Yes, I'm here.
Right. Now, this matter is in court and it could swing either way. But for you, how do you think this will end?
I think parties should sit down at a round table. I will not know how it will end, considering the back and forth, the fireworks, the accusations, counter-accusations. I think parties should sit down at a round table. The federal government has set up a committee. I think it will also be in the best interest of that committee to invite the consultants, to also make their claim, their case, and then also the members of the committee, being members from the Federal Executive Council now, not members of the Governors Forum, also call on the members of the Governors Forum to make their representation. And then the committee can seek independent advice, from experts, in similar matters, and then so to be able to come at a decisive decision. And also, there are allegations of corruption that have been made there is need for EFCC to investigate those angles of corruption, because the governors have accused the consultants of underhand dealings. Also, the consultants have also accused the governors of collecting money. And mind you, if you remember, it was alleged that the office of the Attorney General, the same Malemi, in 2017, brokered that deal. So there's need for a thorough investigation by the EFCC in that regard. And if anybody is found culpable, because this 100 million is not part, it was alleged to have been paid, illegally to prosecute election. So that puts, certain persons at an advantage over their counterparts in the election. So if state funds are used to prosecute the election, there's need for a thorough investigation in that regard. When that is done and transparently seen to have been done, I think all parties, would accept the outcome of such a recommendation. And probably that might form the terms of judgment of the courts.
The $100 million issue is almost like the Nixon scandal, the Watergate scandal, where you try to get one over the other, using state funds to get advantage over the opposition. But that is not where my question is going. My question is, how do we limit the powers of attorney generals in this country? Because Malami is not the only one that has been guilty. We have had them, government after government, and they tend to take advantage of the law against justice. Even Malami, as we said, also was trying to put a judgment of a federal high court in the Gazette when the matter was set for appeal.
Exactly. You see, like you rightly acknowledged there, starting from, you remember, Andoka was almost a lord unto himself. Also, you had the Adokie, there were allegations against Adokie also. So, this government, whilst in opposition, had advocated for a divorce between the office of the Attorney General and the Minister for Justice. The Minister for Justice would be the legal advisor, to the state or the federal government, while the Attorney General would be the chief law enforcer. And like you have in America, the office of the Attorney General is elected, So if you have a divorce between, these two offices, I think that will go a long way in also whittling down the powers of one man who doubles as Attorney General and the Minister for Justice. Because we say power corrupts and absolute power corrupts, absolutely. And then we also need to tweak the Constitution a little bit. The powers of the Attorney General are too enormous. A situation where you have Attorney Generals who, in some cases, in criminal matters, because the Constitution allows them to enter nolle prosecute without any reasons, in criminal matters against state interest, will enter a nolle prosecute and decide not to prosecute. We saw it in the case of Bola Ige in Oyo State. Also, I think the Bar Association, should be involved in the appointment of an Attorney General, so that we'll have an Attorney General who will act in good faith. Because you will find a situation before now where the Attorney General, almost the Bar Association becomes an appendage of the office of the Attorney General, who firms out briefs to senior lawyers. But now, thank God to the current MBA led by Olumide Akpata, that's taking MBA away from the whips and caprices of the Attorney General. But they still need more powers to be able to call an Attorney General to order, prosecute an Attorney General that has fallen out of line. But unfortunately, we have all compromised the process. You do not need a petition to the MBA for the MBA to submit a petition to the Legal Practitioners Disciplinary Committee to call an Attorney General to order. But here, where poverty reigns supreme, when everybody runs to the Attorney General for briefs, then it will be very difficult to investigate and prosecute such a man. So I think in the appointment in the first place, the bar should be involved in the appointment of who becomes an attorney general, so that you have an attorney general who will act in the interest of the country rather than self-interest. But a situation where the president just appoints whoever he wants. During screening in 2015, and Malami said he was first and foremost a lawyer. He became a businessman. Now he's a politician. I wonder what he means by that statement. Maybe he's no longer a lawyer, or that now he wants to play more politics than the law. But he should also remember that there is posterity beckons. Because recently the Supreme Court also, was it the Supreme Court now or I think the Supreme Court gave a judgment against Andoka, restraining him from holding public office. He wanted to be governor in Benue State, but he thought that time would erase the atrocities he committed as Attorney General. Malami is on his own voyage today, but he should also remember that posterity beckons and time. All his atrocities are written in the sign of time.
Well,
but we must all get involved.
Yeah, Mr. Oshoma, I mean, it is the AGF today. Tomorrow it might be the governors and senators, and even Mr. President. So I'm just wondering, perhaps, how do we begin to create systems and structures that will work for us? I mean, some persons have questioned the system of government that we practice, the presidential system of government. I wonder, so how do we begin to create systems and structures? How do we begin to indeed improve on institutions that would ensure that people are not stronger than such institutions?
You see, even in the next dispensation, it's going to be very difficult. Everybody, as I speak to you now, is fixated on who becomes president. Nobody's bothered about who becomes the governor. Nobody's bothered about who becomes the senator or who becomes the House of Assembly member. We're all fixated on who becomes the president, and we think that once a man becomes the president, he will solve all the problems of Nigeria with a magic wand. No, you have senators who will compromise. You have House of Assembly members, House of Rep members who will also compromise. You have a situation where certain persons will be appointed as ministers, and they will compromise, like the case of the current Attorney General that we're discussing. And you have consultants also who will be hanging around the corridors of power, looking for opportunity to make money. All of us see government as an ATM. So once you have somebody up there, you believe it's your turn to also make something. Quickly, I must say this instructively. As I speak to you now, we've recently unbundled the petroleum industry. But has any of us bothered to find out what is happening in that industry? And all of the people that are appointed there, they are even worse than the current Attorney General that we're complaining about now. So what we should do, because all of us are involved, the upstream sector, as I speak with the edifice in Lagos, here, they have gone to Abuja to rent apartments, and now even looking for a way to ensure that the massive edifice owned by them in Abuja, in Lagos, is abandoned. So, but what should we do? If we are not all involved in the electoral process, because you are not a human being except government says you are. You can't be broadcasting except government gives you a license to broadcast. You cannot operate a business except government incorporates you and give you a certificate of incorporation. You can't even own a bank. So the people that are going to take this decision to determine whether you live or not are those in government. And when it comes to electing them, we throw caution to the wind. We compromise. We collect money. We say we pander to religion. We pander to ethnicity and leave out competence, only for us to turn around and complain later. We need to understand that the only way we participate in government is when we all participate in leadership selection processes. And look at people with track record, look at people with credibility, look at people with precedence of what they had done before, and not just get carried away with sentiments and rabble-rousing, and at the end of the day, only for you to turn around and complain later. So that's why you have all of these powers, entrenched in one man who is the president, and then you have powers entrenched in the governors who have become emperors, and they do as they like. And anytime they leave office and you have security agencies or the economic and financial crime agencies going after them, We, the people who they have stolen from, will be the one to complain. Until we are ready to determine who governs us, to be part and parcel of the process of selecting leadership, we will keep going around in this circle. And I don't see, I must say, I will burst your bubble, I do not see any hope in the near future with the way we are still going. Imagine this day and age we are discussing religion. Oh, Christian, Muslim. Nobody is asking the question, what are your actualizable plans and dates for if you become the president? What do you understand by policies? How do you intend to handle the concurrent and the exclusive legislative list? How do you intend to devolve powers to the smaller unit? How do you intend to ensure that there's autonomy for local government, there's fiscal federalism? What do you understand by gender equality? What do you understand by fuel subsidy? How do you intend to deal with the issue of Ruga and all of this? Nobody's asking those questions. We're just banding figures and then, shout slogans and then
Liberals, I believe that Nigerians are beginning to be awakened by the realities that we face in the country and are beginning to be more aware of all of the
Are you sure? The awareness, it's about slogans.
Right. Now, one quick question before we let you go is the aspect of, still talking about institutions, the EFCC investigating the corruption allegations that you mentioned. You talked about transparency in carrying out that investigation. I wonder if you are confident that the EFCC will be able to deliver on that.
If without interference from the same federal government, I have confidence that the EFCC will be able to deliver on these allegations, because you find that, look at without trying to knock the police, look at the case of the Accountant General of the Federation, for example. If it were the police, you hear of an allegations and then the police will say they are investigating. Before we heard of the allegation, the man had been arrested and swiftly the matter had been charged. There are people who are culpable, including this as Abdulaziz Yari's group, the AGF, the NGF. Then you had Bureau de Change people who were part of the conduit. You had special advisors in the office of the Accountant General. You also had commissioners of finance in 9 states. But now it is left for us to ensure that we consistently keep that matter under the top burner. EFCC had done well. Kudos to them. They're doing what they ought to do. For the EFCC, I know that their modus operandi is to investigate, do a conclusive investigation, even before making an arrest, because I've handled petition with them. But you have cases also where there are compromises here and there in certain cases if there are interference. Take, for example, the case of Theodore Orji. Petition had been with EFCC for God knows how long. Till date, there are no conclusive investigation. So if there are compromise, if there are interference from the federal government, then EFCC would compromise the matter. But for this, that is a national disgrace and it's taking an international dimension, I think that if EFCC is called upon to conduct an investigation, and the same Attorney General and the Office of the Presidency does not interfere, then I believe that the EFCC will be able to do a thorough job, despite the fact that there are allegations that the chairman of EFCC was his appointment was influenced by the Attorney General. I know the young man would, has an independent mind and would be able to do a thorough job.
The way the NGF is going about it today, you would think that they are absolutely innocent of anything. But it's clear that there's no innocent party in this dispute over $418 million.
No, there are no innocent parties. There are no innocent parties because if all had played out well and all of the compromises had been met, we would not have heard of these allegations and counter-allegations. Because if the AGF, the NGF, the Nigerian Governors Forums were innocent, they probably wouldn't have collected the 100 million that they were alleged to have collected, when the funds were first and foremost paid. And then also, they wouldn't be appointing consultants here and there to do the job that ordinarily, you don't need consultants to do in cases where funds have been returned. They're already in the coffers of the federal government for deductions. So elections is approaching. there is palpable fear in the land. Some persons want money, others also want money for personal use, others want money to prosecute election. So all of these shouts, I say, it's not about the common man, it's about personal interest. And some governors also are exiting office very soon. So if you begin to make deductions at this point, what is left, to be stolen will not be that much. So all of this, that's why you see all of this multiplicity of litigation for a matter that parties can sit down with an arbitrator and resolve.
So in this case, what we have as consultants are actually the Agbero syndrome. Who yes. doesn't bring the customer? Who doesn't bring the customer to the passenger to the vehicle, but is the one that just says, "Okay, are you going to Ibadan? Come and enter this vehicle." Whereas you already know that the car is waiting for you, and you just walk there without the Agbero.
Yes, since to some extent, some of the consultants are the Agbero syndrome, where you already have funds that have been recovered, and then you appoint consultants. And because also the state houses of assembly are an appendage of the governor's office, extension of the governor's office. So you have a situation, there's already an answer. So just provide the question and work from the answer to the question. That's what happened in some cases. And that's why now that there is a quagmire, and that's why you're hearing all these shouts, allegations and counter-allegations. And that's why Ned Nwoko was bold enough to make that claim, that allegation that indeed more than 100 million was demanded. The office of the Attorney General, helped in brokering the compromise, and $100 million was paid. So what you have is the people, a connivance between people who should guarantee our welfare, now be the one plundering our welfare. And it's really, really, really quite unfortunate. And the time for us to sit down and begin to look at the fine lines from who becomes local government chairman, because the local government from 2017 or so had been alleged to have collectively shared $1.3 billion, while the state governors have been alleged to collectively share $10 billion of this recovered fund. But if you look at the economic generally, you look at the local government level, you will not find where such an amount had been used in any of the local governments in Nigeria. You will not find where 10 billion naira had been deployed collectively in any of the states in Nigeria. So that's why all of these allegations are coming up, because it really, had nothing to do with the common man.
All right. We must thank you, lawyer and advocate for good governance, justice and equity, Luboros Oshoma, for your time on the program.
Thank you.